The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everyone. Mr. Farasi, you'll help me with the pronunciation.
Yes, Your Honor. Good morning. Steve Faraci with the law firm of Whiteford, Taylor, and Preston.
Thank you. You may proceed.
Thank you, Your Honor. May it please the court. As I mentioned, my name is Steve Faraci with Whiteford, Taylor, and Preston, and I'm here on behalf of the appellants, Charles E. Ayers Jr., Ralph Costin, and Jesse Barber. I would like to reserve 5 minutes for my rebuttal time. I'll start here. The appellants respectfully ask this court to reverse the district court's award of damages to the appellee in the amount of $157,195, both for breach of contract as to all of the appellants and for fraud as to appellant Ayers. And while this court has been asked to address multiple errors made by the district court below, each of the errors flow from one fundamental mistake, and that is the award of compensatory damages to the appellee, despite the appellee's failure to prove compensatory or actual damages. As we look at the record, it is clear from the record, both in terms of the evidence and what was put on and the governing documents, that the award of damages was speculative, it was contrary to the evidence, and it awarded plaintiffs a windfall. Put another way, the fundamental question that this court must consider is whether the district court erred by awarding compensatory damages when the appellee Beatley neither showed that the damages that were awarded were probable or supported by the evidence. If the appellants are correct on this point, then the district court's awards for both punitive damages and attorney's fees are likewise in error, because those awards fundamentally require an award of compensatory damages. As to the case, it arose out of plaintiff's claims for breach of a settlement term sheet that had been entered into between the parties to resolve a prior state court litigation. The settlement term sheet involved two specific provisions that are relevant to this appeal. Section 2 of the settlement term sheet had provided that defendants or appellants would pay to the appellee $134,000 on or before July 17, 2019. Section 3 of the settlement term sheet provided that the appellants agreed to assume appellee's obligations on a certain loan that appellee had with Fulton Bank in the original principal amount of $157,000, which obligations included paying applicable interest payments to Fulton Bank under that loan. And that Section 3 of the agreement also required that appellants use best efforts to obtain Fulton Bank's consent to assume the loan and release appellee. Now, the court below found the following relevant facts from which appellants do not appeal from. Appellants did not make their $134,000 payment on or before July 17th, but payment was made, including interest at the judgment rate, and it was made prior to any ruling on a breach of contract with respect to Section 2. Accordingly, the court found that there was no damages with respect to any breach of Section 2. As to the Fulton Bank loan and the Section 3 of the agreement that we're talking about, the court found that the appellants had made all applicable interest payments, albeit some of them late and after the due date of those payments, up through the time that the loan was satisfied. The court found that the Fulton Bank loan was satisfied through the bank's exercise of certain rights in cash collateral that had been put up by a former partner of the entity, a gentleman named John Woodfin Sr. The court also found that no further amounts were owed to Fulton Bank in connection with that loan, and found that John Woodfin Jr. as administrator of the estate of John Woodfin Sr., had testified that there was no intention by Mr. Woodfin Jr. as administrator to bring any claims against the appellee for the amount of the cash collateral taken by Fulton
Can I
Bank.
ask a question, please?
Yes,
Let me ask you this question. When you argue that no demand has been made for the payment of the $157,000 and that there's no intent to do so, aren't you really arguing that that claim is not ripe?
It's both, Your Honor. And that is why we phrased it as it's an error, because it's both speculative, it's too remote, and so to your point, not yet ripe, and it's also contrary to the evidence. So I believe that the court below could have accepted John Woodfin Jr.'s testimony that there is no actual intent to bring a claim and that the estate is closed, and therefore there is no claim and therefore no damages. Alternatively, the court could have and should have said the mere possibility that a claim could be brought by the estate is so remote as to not be ripe. And to your point, if John Woodfin Jr., as an example, were ever to change his mind as administrator of the estate, a claim would accrue at that time under the settlement term sheet for the appellee, and that's sort of the point. He's been awarded damages to which he was never entitled under the settlement term sheet and has received a windfall because...
Well, now that the estate has been closed, can any claim legally be brought for the 157 by anyone since the existence of the claim was known during the time the estate was open by the administrator? Can there be any legal claim now by anybody?
I don't believe that it can. The estate is closed, Your Honor. There was a debts and demand hearing. In reviewing that question, I do believe there is some case law in Virginia that suggests that notwithstanding the debts and demand hearing and notwithstanding that it has been closed, that a administrator can reopen and still seek those damages.
As to a claim he knew about during the time the estate was open?
That is the unknown question. So the law only speaks to the fact that a claim could be made by an administrator even if an estate is closed. I believe there would be certainly an argument that he was either stopped from doing so because he knew about it during the course of the debts and demand hearing and did nothing, and quite frankly chose not to do anything, as his testimony has indicated. So
Can you represent who the beneficiaries of the state are? Can you represent that? Who they are? Because as administrator, he has a fiduciary duty to collect all funds owing to the estate. He has no option in that regard. Now, what has he done, you know of, that has somehow firewalled himself against a claim for lack fiduciary duty? Because when you stand in the shoes of an executor or an administrator, your first job is to collect all debts and properties owed to the estate. So the estate is an entity to itself. I'm not sure that an administrator can, on his or her own, say, I'm not going to collect that which the law in Virginia says you're required to collect. What's your authority for saying that they have that option?
Your Honor, you asked two questions. I'm going to try and address them. The first is, can I represent who the beneficiaries are? The beneficiaries are Mr. Woodfin Jr. and his sister, who is also, and I believe his mother, who is co-administrator, may also have some benefits with respect to that estate as well. So that's my understanding of the beneficiaries. As I mentioned, I believe that an administrator of an estate has the ability and the right to settle claims. While he may have a duty to collect, he has the authority under Virginia law to determine in what manner he will seek to collect all debts and whether he may compromise certain claims. Certainly a fiduciary acting on behalf of a state has the a right and ability to do so. And one of the things that you'll see in the record below is that Mr. Woodfin, in his capacity and fiduciary of the estate, was well aware of the issues associated with the Anchor Point development out of which this loan arose, and had concluded that the entanglements in connection with the Anchor Point development were so significant and had been such a drain on that which his father's investments and ultimately the estate's investments, that it was appropriate not to take any further action to try and collect those debts and ultimately try to sell the property and get out of the development. That was the testimony at trial. And I think it was a reasonable and reasoned business decision by a fiduciary on behalf of the estate that to go further and try and collect those debts would result in further losses to the estate.
Well, yeah, I don't see how that could be the case now. All you have to do is just cash the check. You know, all you do, you got a judgment, you got potentially a judgment debt right that's owed by your client, and just cash the check. Now, I agree if it was still entanglement and litigation. I don't know how a fiduciary can say, you're absolutely right, a fiduciary under Virginia law can obligate and make, has the power to do so, to enter. But it's got to be consideration. It's in the best interest of the estate. And I don't see how a potentially liquidated, collectible amount that you can just cash the check would somehow be in the best interest of the estate to say, I'm going to eschew that opportunity. Because, see, it's interesting that once Mr. Woodfin passed, and it's unfortunate for the family, but the estate is an entity of its own. You could be a beneficiary of the estate, but the cap you wear as fiduciary is different. You know, your heart might be one way, but the law says you have another one. It's for the estate. If you don't want it, give it away. If you're a beneficiary, I don't want the money, I'll give it to charity. You can. But it belongs to the estate, which is an entity under Virginia until you say it's closed. But I think it's a question of whether that's the case. But anyway, I understand your argument because you're relying on, and then you told me to answer the first question. How do you know that the other two members agree with this? That they signed on to, that they want to give this up to?
There's no written document in the record that confirms that. And if I may, Your Honor, one follow-up point to a comment that you made, that you said all he has to do is cash the check, he being John Woodfin Jr. as administrator of the estate. Remember that the award that we are on appeal from here was not an award that directed Mr. Beatley, gave him a judgment and directed him to pay it over to the estate. It is an award directly to the appellee Beatley for the full amount of the loan to which he no longer owes on, and any claim has not yet been made.
Absolutely right. And that might be something that potentially could be adjusted in terms of the award. I mean, that is a sticking point. I agree with that, the way it is now, but that's still in the breast of the court in terms of how that ought to be adjudicated. But go ahead, Shar. Thank you so much. It's very helpful.
Very good.
Judge
I had a question.
Gallagher has a question.
In your reply,
Yes.
Mr. Faraci, you suggest that the appropriate remedy would be for the defendants to indemnify Mr. Beatley against any prospective claim from the Woodfin estate. Do you have any authority under which that could be a potential remedy?
So, Your Honor, I think the way in which I phrased it, and I think this is accurate. If you actually look at the settlement term sheet in Section 3, because what the obligation was, and when we look at that, there was no obligation that the appellants ever pay appellee Beatley $157,000 to satisfy the loan. The obligation was to assume all obligations with respect to that loan. And so I believe an indemnification obligation exists to the extent that the estate were ever to bring a claim. And it is to Judge Traxler's point that it goes either towards what I have called the damages being speculative issue, what Judge Traxler perhaps more appropriately called ripeness. So to the extent that there is a claim that is ever raised, I believe there's a duty under that language in Section 3 that exists, and therefore that is why I raised that is the appropriate remedy. I don't think that the court would need to layer on an additional indemnification obligation. I believe it exists in the document that's within the record. I see my time is almost up. So the last point that I would make, and I think it's an important one, is to note that the award as it stands right now gives Applee Beatley a windfall. And this is, particularly highlighted when we look at it in terms of the award that was made based on fraud as to appellant heirs, because the law is clear in Virginia that no damages exist if a plaintiff is in no worse position than if the fraud had never occurred. And here, Plaintiff Beatley is in a position where he doesn't owe on a loan. No claim has been made against him for the amount of the cash collateral seized, and yet he's now been awarded $157,000 by this district court. We believe it was error.
The second part is right. He hadn't paid, no claim has been made, but the first part, the second part, he said he doesn't owe it. Well, he does owe it.
Your Honor, my time is up. May I respond very briefly? What I said was it is not owed to Fulton Bank, and no claim for the successor has been made. I thank you for your time this morning, Your Honors.
Thank you so much. Mr. Thomas?
Yes, good morning. Chief Judge Gregory, Senior Judge Traxler, and Judge Gallagher. My name is Norman Thomas, and I represent Mr. J. Irvin Beatley, who was the plaintiff below. I'd like to also reserve 5 minutes for rebuttal time. I want to go right into this point about the $157,195. Judge Gallagher, you raised the point about indemnity. They acknowledged in their the reply brief at page 8, this issue of indemnity. And once they did that, they have acknowledged more than they realize. There are 2 cases that are on point that indicate that Mr. Beatley was entitled to the entire amount of the liability once Fulton Bank called the loan, even if he had not yet retired that debt. One is from this court, and these, I want to give the citations for the court. State Planters Bank and Trust versus First National Bank. It is reported at 76 F 2nd, page 527, and at page 532, it discusses this concept of a contract of indemnity against liability. This is not an indemnity to reimburse. It's an indemnity against liability, and they failed in that regard. The court finds in that case that the legal liability is incurred and not the actual damage sustained as the measure of damages. And the Fourth Circuit relies on a Virginia case, Oriental Lumber Company versus Blades Lumber Company at 50 Southeast 270. And that case discusses this concept in Virginia law, which is controlling here, of a contract of indemnity against liability. And I'll quote very briefly from it, but it is the dispositive case here. Quote, a right of action accrues at once to the indemnity to recover the amount of the debt without regard to the question of whether or not the indemnity has yet paid it.
Mr. Thomas,
So, yes,
are these cases in your briefs?
they are not, and we did not cite them until they acknowledged that this was an indemnity matter. And as appellees, we were at that point, we felt free to raise this issue to the court that these dispositive cases made it so that the debt was ripe when Fulton Bank called the loan all the way back in February of 2018. Once they assumed the debt, once they assumed the obligation to pay it, then once Fulton Bank called it, then under Virginia law, as recognized by the State Planters Bank case here in the Fourth Circuit, Mr. Beatley was entitled to the entirety of the liability. And once he receives the damages, then of course, as Chief Judge Gregory has noted, the estate still has an asset, and that asset is the estate's ability to claim directly against Mr. Beatley for the $157,000 and $195 that it paid to retire the Fulton Bank debt.
All right, let me ask you another question. Is it your position that a beneficiary of the estate could put a viable claim for the $157,000, even though the estate has been closed and even though the administrator knew about this claim before the estate was closed?
Absolutely, yes.
Do you have a case? Could you tell me what case you rely upon for that proposition?
Well, in our brief, we cited the statute 49, I believe, -27, and we did cite a number of back to say that the person that has paid the debt is in the most favored position in Virginia law. Your Honor, I can pull up my brief and cite that to you.
I have your brief. So the cases you rely upon are in your brief.
Yes, sir. And during the questioning of Mr. Woodfin Jr. at the trial, trial counsel, Mr. Burr.
No, my question is a legal question. It has nothing to do with the testimony.
Well, the beneficiary.
I didn't want you to get sidetracked.
Yes, sir, Your Honor, and thank you. But the beneficiaries have the right to not only demand, but to require the administrators to pursue the asset. It's important to remember, too, that the debt was called in February of 2018 by Fulton Bank. The statute of limitations has far from run. It's a written contract for which the limitations period is 5 years in Virginia. And so all Mr. Woodfin or his mother, Nancy Woodfin, who is the co-administrator, need to do is make the demand. And under the statute that we've cited in our brief and the cases that go back to, at least one of them goes back to the 18th century, all they need to do is make demand on Mr. Beatley. This fact that Mr. Woodfin says the estate is closed doesn't make a bit of difference to the beneficiary's right to demand that he undertake his fiduciary duty. So the claim is ripe. It's been ripe since the call of the debt under the applicable statutes of liability, of indemnity against liability. I also wanted to just
Norman,
reinforce. I'm sorry.
Norman, before you go to your next point, because I saw you get you off your track once you start that. What do you say about this windfall? And notwithstanding, you're right. I think you're right that the state being closed now simply means that the beneficiaries have control of what now belongs to them, which would be the right to call on this loan, subject to, of course, statute of limitation, as you alluded to. What about the idea that they never did do that, and it never happened, and the statute has run? Is that a windfall, or is that something that we should be concerned about from a legal standpoint? Just give me your take on that.
Yes, Your Honor. It is not a windfall because the controlling cases say it is not. That's the first answer. That's the State Planters Bank case and the Oriental Lumber case. They articulate at length that if the indemnitor assumed the debt, then once the debt is called, the indemnity is entitled to the entire amount from the indemnitor without regard to whether they've paid that debt. But also, there's a second point I'd like to make, and that is Mr. Beatley still owes this money. He has not been released. There is no release from the estate. A debts and demands hearing means nothing. That only protects the administrators from dispersing the estate as to creditors. There's been no release as to this asset of the estate to Mr. Beatley. So he is still, as the district judge found, on the hook, but just to a successor creditor for the exact same liability, the liability on the Fulton Bank note. So those would be my comments on that.
Thank you. Go ahead with your...
All right, and the fact that the $157,000 is damages then supports the predicate for not only attorney's fees award, but also for the punitive damages award against Mr. Ayers. But I want to comment about Mr. Costin, because under Virginia law—
Mr. Thomas, before you leave that subject, presume, just for the sake of an argument, this is just a hypothetical, that $157,000 in damages, that amount is not available to you as a predicate for the punitive damages. You also argue in your brief that even if it's not the $134,000 payment plus interest, or the failure to pay that money on time would be a predicate for the punitive damages. Could I hear you on that point, please?
Yes, Your Honor. And there's two prongs to that argument. The first is this: once this federal lawsuit was filed, there was a 12B6 motion to dismiss file. The court swept that aside as meritless. And then the parties engaged in months of litigation. There never was an answer filed by these defendants denying that they owed the $134,000. And that's why we moved for partial summary judgment on the pleadings. So when, as the district court found, when judgment against them was imminent, they came rushing in and they paid it to thwart any punitive damages claim. But what I would note is this: it's a judicial admission. They never denied. Once the complaint was filed and served on them, they had an amount of time to deny that they owed this debt, and they didn't. And Mr. Beatley argued it as damages. So really, it's an admission of these damages. And the fact that they paid it early doesn't make a bit of difference. It was still damages. And as the courts have found, this concept of—
when you say it was paid early, you're referring to it being prior to a ruling by the court on your motion. It's actually late because it's beyond— if you look at the date it was due, it's late.
Well, agreed. It was admitted damages. That is perhaps the best way to express it. They admitted the damages by, number one, failing to deny the debt, and number two, paying it in full. And that is an admission. So we say that admission is a sufficient predicate for purposes of damages. But we've also cited a number of cases that say that it's not so much the award, but the showing of actionable harm. And there were two cases we cited. One of them was the People Helpers Foundation case at 12 F 3rd, page 1321. And it discusses in terms of actionable harm as opposed to the outright award. And then we did cite a very thoughtful opinion from the Southern District of New York, the Klein v. Spear and others case. It's from 306 F Sup 743. It's a 1969 case. And Your Honor, in that case, one of several defendants settled with the plaintiff by paying the money. But the plaintiff still wanted a punitive damages award, and the court allowed the plaintiff, although damages, the compensatory damages were satisfied, to show that those damages were in fact owed for a predicate for punitive damages. And the court said that the better reasoned authority appears to require only the showing of actual damages and not demand that they be actually awarded. So on those two prongs, we rest our argument that the $134,000, when it was paid as admitted damages, and therefore could be the predicate, not only for compensatory damages, but for the damages for fraud and also the damages for the conspiracy to bring about contract breach, which we have argued the district court also should have found in our favor. Turning directly to Mr. Costin's fraud.
Can I stop you for 1 minute and ask on the conspiracy point? Why is the conspiracy count important here? That the damages, the $157,000, have already been awarded on the breach of contract claim. What practical difference does it make as to the conspiracy count?
Well, Your Honor, we're being thorough for our client. We want to make sure that our client on every theory of recovery has the damages compensated. And in that regard, Mr. Woodfin from the very beginning, combined with Mr. Ayers, with Mr. Costin's knowledge, and as the district court found, he knew of the scheme. And they got together for the sole purpose of thwarting Mr. Beatley's entitlements under the contract. And that is the type of interference with a contractual relationship involving a third party, here Mr. Woodfin, that is tortious and is conspiratorially so, because they were all in it together. We've met all the elements. And where the district court fell off on all of these was, first, not recognizing the $134,000, not recognizing that fraud in the inducement as to the contract is fraud in the inducement as a whole contract. The court parsed between the 157 and the 134,000, but in Virginia, a contract is interpreted as a whole, and fraud in the inducement as to the contract is fraud in the inducement as to the whole. So if any material term was misrepresented in terms of an intent to perform it, it was fraud in the inducement. And that's why Mr. Costin is equally liable with Mr. Ayers for that fraud. My argument time is up. I'd like to just simply reserve the rest for the final argument.
Thank you, Mr. Thomas. Rashi?
Yes, Chief Judge Gregory. I'd like to start here with respect to the cases cited by Mr. Thomas. And while I will not profess to have had an opportunity to review them in great detail during the course of Mr. Thomas's argument, one salient point I think is critical. There's a distinction between, even if it is a contract of indemnity, when you talk about a breach of contract, the elements necessary for recovery on a breach of contract don't change by virtue of it being an indemnity contract versus some other type of contract. And in Virginia, every breach of contract claim requires the proof of actual damages. And so in a case where you have a contract of indemnity and you have an indication that as to the indemnitor, the plaintiff is entitled to the entirety of the amount regardless of whether they have paid the underlying debt, not relevant to the issue that we have in dispute, because by the time a claim was made here by the appellee, there were no damages to him as to Fulton Bank. So what we're talking about now is what, if anything, remains as to potential liability for the amount of the 157. And what we have is the potential, what I have called the mere possibility, of a claim by the estate. And so I do not believe that the existence of those cases and talking about how a contract of an indemnity would work, particularly in the instance where you have someone who sues in advance of the time that they paid the underlying debt, it's essentially a situation where if you still owe the underlying debt, you can get those damages because you owe the underlying debt. Here, the underlying debt as to Fulton Bank has been satisfied, and there is a mere possibility of a future claim that could be raised. So I do think it's an important distinction.
Yeah, I have to look at the cases carefully too, but it seems to me, as maybe I may be wrong, Mr. Thomas knows better, he'll come back up. It seems to be those cases suggesting that the time that you owe the money, your clients owe the money, is at the time of the call. That's the triggering point, which might answer the question, maybe a little, my dear colleague, Judge Traxler, as to what point is it due? Is it, because it's not a right to reimbursement, it's indemnity. Different, isn't it? Reimbursement would be with, well, you have to get back what you paid, but indemnity is a different question. It seemed that the case said at the point where Fulton Bank called the loan, then that's the time that you, as the person who's supposed to assume, they had to pay up. Instead, someone else did. Instead, they became a successor to Fulton Bank, and they stand there. So the point of indemnification is at that point. That's what I think what the case is saying, and you owe it. You owe it. And I think that's what the case said, but I need to look at it further. But I think that's the point of the case. It's not reimbursement. It's indemnity. When is that? When the call was made. That's what it's saying. That's what happened. It's undisputed that the Fulton Bank no longer holds and somebody stepped in and they sort of it's what they call like in Broadway, like an angel, paid it. And you're saying, well, until the angel collects on you, I'm not going to give you anything. But the question is, in the case that no, indemnity triggered your time to pay, not when we had to pay. That would be reimbursement. But anyway, but I may be wrong about that, but I haven't looked that careful. But I think that's what the case is saying in terms of the timing. But you go ahead.
And your point is well taken as to the accrual of a claim, Your Honor. But I don't believe that there's anything about those cases that discuss the accrual of a claim regarding a contract of indemnity or the timing of a payment that somehow abdicate the responsibility that a plaintiff has to prove their damages with reasonable certainty and to do so as a part of their prima facie case of breach of contract. That would be a meaningful change in Virginia law. The cases are too many and too numerous, and we've cited a number of them in our brief, that establish that when you are going to seek a successful claim for breach of contract, the proof of actual damages proved to a reasonable certainty has to be a part of your proof. And so I do not believe that the nature of the contract being an indemnity changes it. What it does is require an analysis along the lines of whether those damages are speculative, whether those damages are too remote, or whether the claim is not yet ripe. So I think it's an important point. I see my time is up, and thank you for you.
I asked you a question. You had a short time. Is something you, 30 seconds, want to close in? I did.
One final point on the conspiracy to breach a contract that was raised, and that is with respect to a conspiracy to breach a contract does not exist as a viable claim under Virginia law. And if you're talking about conspiracy that relates to the tortious interference with contract, which really has been raised, when you deal with that, there has to be an underlying wrongful act. And all of which was pointed to in the record was an encouragement for Woodfin to exercise his legal rights as a creditor. That is not an underlying tortious act, and that is another reason why that claim failed. And I thank you for your time and for the indulgence of the additional minute.
Thank you. Mr. Thomas, you have time reserved.
Thank you, Chief Judge Gregory. The $157,195 as a matter of law is the amount. It's the exact amount of the Fulton Bank claim. And I don't normally do this in oral argument, but I'm going to quote a very brief passage from Oriental Lumber, which is the case and the page number that the Fourth Circuit cited in the State Planners Bank case. It states that, quote, if the act which the indemnitor bound himself to do was to pay or discharge a debt, and he fails to do so, a right of action accrues at once to the indemnity to recover the amount of the debt without regard to the question of whether or not the indemnity has paid it, end quote. That's dispositive. And on that issue, it's a matter of law. It's not a matter of analysis by a court. What the defendants are here angling to do is painfully obvious, and that is to have this court reverse the district court, then Mr. Woodfin claims against Mr. Beatley, and then the defendants again default on paying the $157,000 debt. And Mr. Beatley has the joy of suing a third time for that amount. And that's not what Virginia law requires him to do. And the Fourth Circuit has recognized the same in the State Planners Bank case. I also want to address this point about the conspiracy. My colleague has indicated that, well, Mr. Woodfin was only seeking to collect amounts that were duly owed, that amounts that were appropriate for him to do so. The Fourth Circuit has said that although one may be acting in their own legal interests, there is no protection from conspiratorial conduct when they know or have reason to know that they will interfere with the performance of a third party's contract. And Mr. Woodfin didn't know it, didn't just know it. It's the reason that he sent these repeated demand letters. Everything he did was to thwart Mr. Beatley's entitlements under the settlement agreement. He knew that's what he was doing. Mr. Ayers was urging him to do it. Mr. Costin was repeatedly asking Mr. Ayers, have you heard back from Mr. Woodfin? What are we going to do? And Costin also testified that the failure to pay Mr. Beatley was done at Mr. Woodfin's request to give Jack Woodfin time to decide what he wanted to do. The Commerce Funding Corporation case at 249 F 3rd 204 at page 210 interpreted Virginia law and quoted the Chaves v. Johnson case of Virginia law to say that there's no defense to this conspiratorial conduct simply by virtue of the fact that the third party interfering with the contract, here Mr. Woodfin, had a lawful debt that he may have wanted to collect at the same time. At this point, I do want to mention that we are seeking appellate attorney's fees upon the affirmance of the district court. We're seeking that Mr. Costin be found guilty or liable for actual fraud, just as Mr. Ayers was, and that on remand that the district be instructed to at least consider an award of attorney's fees and punitive damages as well against Costin, not only for his role in the fraud, but against Ayers and Costin for their role in the conspiracy as well.
Can I ask a question?
Yes.
Just based on what you just said, you expect us to find that Costin is liable? I don't know how we could possibly do that. It would involve factual findings that we obviously don't have the authority to make, particularly in the face of contrary findings by the district court.
Your Honor, the facts are in the record, and the law.
I know, but we.
If I may, I may not satisfy you, but I do want to answer you.
I understand.
In Virginia, if you represent and enter a contract, if you represent entering certain performance of material terms, and you don't at that time intend to perform those promises, that in and of itself is actionable fraud. And we have cited those cases. And that is what Mr. Costin himself admitted doing. So we do feel that the record is complete on that, and that his fraud is fraud as a matter of law based on his own admissions.
So
thank you.
Are you saying that's sounding in sort of covenant to warrant of good faith, or is it inducement?
It's fraud in the inducement, Your Honor. When Mr. Costin entered into the settlement agreement, intending not to pay the $134,000 upon its due date, and the amount and the date it's due are both material terms, he misrepresented as a matter of law under Virginia jurisprudence an intent to perform his promises. And that in and of itself is fraud. And
but wasn't that only as to the $134,000?
Actually, Your Honor, under Virginia law, if you are fraudulent.
No, I'm talking about the factual findings by the district court. When you say his intent, go ahead.
No. Please don't let me interrupt you, sir.
No.
The district court parsed between the $134,000 and the $157,000. Our argument on appeal is that fraudulent inducement as to any material term is fraudulent inducement as to the entire contract. And that's the Packard-Norfolk case that we have cited in our book.
But as Judge Traxler said, you didn't prevail on that, so you got an uphill climb, and it has to be clear error in finding of fact.
Well, Your Honor, our thesis here is that as a matter of law, the district court parsed between those two damages amounts when it should not have done that. It was fraudulent inducement as to the contract as a whole, and that would resolve it on a de novo question.
All right. I think we understand your argument. No further questions. Counsel, unfortunately, we cannot give you the, hopefully the pleasure, but certainly it's an honor and I hope it's mutual to come down and shake your hands because we're in this virtual reality now. But please know that nonetheless, our gratitude and respect for your advocacy here today was very helpful, and we appreciate you very much. And we hope that you will stay safe and be well. With that, I'm going to ask the clerk to recess the court briefly.
Thank you.
Thank you, Your Honors.
Thank you, counsel.
This honorable court will take a brief recess.
Jackie.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Tony?
Good morning, sir.
Morning.
Mr. Davidson, you may proceed.
Thank you, Your Honor. Good morning, Your Honors. I'm John Davidson here for the defendant, Mr. Sigler. Your Honors, the agreement of criminal minds to work together for a common criminal purpose is the essential evil at which the crime of conspiracy is directed. Conspiracy is different and often seen as worse than the act of committing the underlying crime. So in this case, Mr. Sigler was not charged with selling some methamphetamine on one day, March 9th, 2016, in Nevada to Stephen Sino. He was charged instead with conspiring, with agreeing with a bunch of people to distribute drugs in Southwest Virginia. So let me start at the outset with what I'm not saying, because I then want to get to the heart of the particular evidence in this case pretty quickly. So, Your Honors, we're not here in a civil case looking at a district judge's granting of a Rule 56 summary judgment motion and asking if maybe there was a scintilla or more of evidence supporting the non-moving party. We're here in a criminal case with a man who's been locked up for more than 20 years or will be locked up for more than 20 years. So the question isn't today whether there's a little evidence to support conspiracy. The issue instead is whether there's substantial evidence, evidence that a reasonable jury could accept as proof beyond a reasonable doubt. Now, our argument, of course, today is that there's not substantial evidence of an agreement to distribute drugs to others. And then we would certainly add on to it, let's not forget there's virtually no evidence of an agreement, a conspiracy to use a communication facility in furtherance of a felony drug offense. Now, why do I say that as to the facts and the law? I'll start with the law briefly and get right into the facts. On the law, as I said in the briefs, Your Honors, I think the 7th Circuit in the Long case, the 11th Circuit in the Deckel case, the 9th Circuit in the Lapierre case, all had it right. There must be an agreement in addition to the underlying purchase agreement that the buyer will be reselling the others. Large quantity sales alone, let alone one large quantity sale, does not distinguish a conspiracy from an ordinary buyer-seller relationship. The 7th Circuit said if the evidence is equally consistent with either a buyer-seller relationship or a conspiratorial relationship to resell drugs to others, the jury wouldn't be able to conclude beyond a reasonable doubt that there was a conspiracy. So let me get in on the facts here. Ms. Hudson's a terrific lawyer and also a friend, and I would say that I want to respond to some of the hardest shots I think she gave me in her response brief because she was trying hard to say, no, there is enough evidence here. When I looked at it, the evidence of conspiracy here, I think ultimately, conspiracy, agreement, ultimately amounted to the word deuce, or maybe looks like it's going to be, by Mr. Sino, a man who never testified at trial as to what he said, let alone what he meant. Deuce looks like it's going to be, is that maybe a scintilla? Is that a little something? Yeah, maybe, but it isn't substantial, and it falls quite a bit short of what this court said in Hackley, or where this court in Hackley was already plainly uncomfortable. What it said was the lowermost limit of what it would accept as conspiracy to distribute drugs. Hackley, there was a whole lot more. In Hackley, Mr. Hackley himself, the defendant himself, proclaimed people deal with him because he doesn't rat out others, and that not telling on others was the whole principle of the game of drug dealing. Mr. Hackley tried to kill the witness against him, the witness who heard him talking about getting the drugs that he was going to sell to that witness from his suppliers in Maryland over a very long period of time. And we don't have any of this here. Now, I don't want to forget this, Your Honors. Again, we really just don't have any evidence of a conspiracy to use a communication facility to commit a felony drug offense. But let me stick with the conspiracy.
Well, counsel, let me ask you,
Yes, sir.
there is evidence here that before the transaction could occur, Mr. Sino told Mr. Ziegler that he had to confer with other individuals as to timing and amount, and they had at least 2 calls to that effect. So he knew there were other persons involved in making the transaction go. And if you accepted the evidence that the deuce was the 2 pounds of methamphetamine that were seized after Mr. Sino left Mr. Ziegler's residence, we have a number of cases that say that the amount of drugs is a vital factor in determining a conspiracy conviction.
Thank you, Judge Agee. It's always a challenge to inherit a case on an appeal, particularly where there's not a transcript of calls made. So I'm stuck with what I hear on audio, and I know that's the life of an appellate judge. I understand that, but I would say, Your Honor, that I didn't hear Mr. Sino saying to Mr. Ziegler. There was evidence that Mr. Sino was talking to others about having, selling and whatnot. But what I think where Ms. Hudson hit me pretty hard, and understandably so, is she said, well, look, Mr. Sino called Mr. Ziegler right after he was having these conversations with the people in Virginia. And what I would say is that may show what Mr. Sino's intentions and understandings were, but it doesn't say what Mr. Ziegler's intentions and understandings were. I may well tell a John Doe or Mr. John Doe that I'm going to go to my sandwich guy and go get him a sandwich. And then I may go to Jane Smith and buy a sandwich from her, and then you'll give that sandwich to John Doe. That doesn't mean that Jane Smith and I have conspired together to distribute a sandwich. We don't know what's going on in Jane's mind.
Mr. Davidson, I think
another issue that... Yes, sir.
Yeah, I think your point is well taken in terms of response to that part of what Judge Agee was asking about, but not the point of this. Are you saying that you dispute that the record indicates that Mr. Sino indicated that other people had to be involved in the connections? You said it in a polite way, but are you saying that you read what's in there, or you heard what's in the record, and you didn't hear what Judge Agee just said? Or that's very important. What is your position on that? Yeah. Are you saying there's no reference? Are you saying there's no reference that Mr. Sino told your client that he had to confer, not who they were, but confer with people in Virginia or other people that had an impact on when or how much he sold to him and what he sold to him? Are you saying that doesn't exist in the record? It's very important.
Your Honor, I know it's important, and the last thing I'd ever want to do is mislead the court as to the record. I listened again last night, and if it's there, I simply missed it again is the best answer I can give. And I didn't catch that in the response brief either, that there was a specific statement to Mr. Ziegler, I'm conferring with people in Virginia or elsewhere to talk about these drugs. If it's in that record, I simply missed it.
I just want to know what your position. Ms. Hudson will be able to help us with that when she comes up. But go ahead with your argument. Go ahead.
Let me just jump in if that's okay.
Yeah, sure, yeah.
I think maybe this is where the issue lies. The evidence, as I understand it, was the statement that I think you referenced earlier. From what I understand, this thing is going to be a deuce, and we'll know for sure by 9:30 the next morning. I think the argument, and I guess the argument you're making, is that you couldn't draw a reasonable inference from that he was conferring with other people in terms of the amount for distribution.
No. Thank you, Judge Gallagher. The looks like it's going to be our simple. We're not saying that's no evidence. We're saying that's just too slender a read. That by itself, without a whole lot else there, that's not enough to be substantial evidence. It's something, it's there, but when you compare that to what was piled up in Hackley, it's not as big as that. So for your honors to rule against my client in this case, I think you would have to say that the evidence in this case is at least the equal or the superior of Hackley. And when I look at the record in that case, as your honors wrote about it then, and the record is this in this case, as I listen to it now, that's just not the case. And then the last thing I would like to touch on before I move on, there was the issue that he ran away. That is, he didn't appear for court, and that he ran away at some point. And Ms. Hudson understandably points that out to me. I would like to point out, though, that, and I didn't cite this in my brief, and I want to do it now, The Wong Sun case is a Supreme Court case from 1963. It's 371 U.S. 471. There, the Supreme Court told us that flight evidence has long been criticized as of dubious value. Even older Supreme Court case, Alberti versus the United States, 162 U.S. 499, says, the reason why that running away evidence is so dubious as evidence of guilt is that sometimes people don't want to be falsely accused. Sometimes they may be fearful of, for another reason, like not wanting to have to go through a trial. So I don't think that is enough of a read to huge 22-year-old or 22-year sentence on. Your Honors, if I might move to the issue of the error with the jury instructions and the jury verdict form as to using a communication device in furtherance of a felony controlled substance offense. I believe that my friend Ms. Hudson correctly conceded that it was a plain error. She's not conceding that it should be reversed on those grounds, but she conceded that there was a plain error that the judge should have instructed and put in the jury verdict form that it was in relation to a felony drug offense, not just anyone. And so the issue comes down to, well, does this make us, do we really hit that third thing where did this really affect his substantial rights? And I thought about that, Your Honors, and I hearkened back to in 1996 when I was clerking for a district judge, and I thought about it and I thought, one less conviction, one less object of a conspiracy, and the district judge may well have given him less time. Plenty of district judges do add up all the crimes committed. There are plenty of district judges who don't give an air quotes freebie, and I don't mean to be cavalier when I say that, but don't give a freebie in terms of crimes committed. So to say that that no way, it's improbable that this district judge cared when fashioning the sentence here that someone committed the additional crime of conspiring to use a communication device.
Mr. Davidson,
Yes,
are
sir.
you making a sentencing argument now? Because I'm not remembering that from any of the briefing. I thought your argument went to the verdict form itself, but it sounds more like a sentencing argument now.
Yeah. Your Honor, what I'm trying to do is deal with the issue of plain error. The jury instructions, the erroneous jury instructions and jury verdict form weren't objected to. So even if the error was plain, I have to do one other thing to get Your Honors to rule for me or for my client, which is to show that in addition to being a plain error, that it affected his substantial rights. What Ms. Hudson said in response, saying, no, it was a plain error, but Your Honor shouldn't reverse. What she said was, well, it wouldn't have made a difference on the sentencing guidelines anyway, so there's really no substantial impact on Mr. Sigler. You don't need to notice this plain error. And I'm saying in response that you actually should, because it may well be this district judge would have sentenced him less if this crime disappeared on us. This judge already engaged in a variance below the sentencing guidelines, so he may well have done that. And then
I understand your argument, but have you made that before today?
No, I'm responding to her response brief, Your Honor. I was saying immediately in my merits brief, I was saying this does in fact impact his substantial rights. And I'm now replying to Ms. Hudson's very good response to me. Best I can do with that. And then, Your Honors, before I leave this point, I quoted from the Supreme Court's 2018 plain error case, which I think is the freshest one we have. It's the Rosales-Morales case. And there they talked about, in addition, when circuit about whether they want to notice a plain error, they really ought to look at, this plain error, is that going to affect the public reputation of the judicial proceedings, the integrity of them, something like that. And here I would certainly say, just looking at this, it would be awfully hard, just me as a lawyer, to go to Mr. Sigler, to Mrs. Sigler, his wife, to really anybody and say that, yes, the jury did not make a finding on an essential element because the judge didn't instruct them on it, and that still doesn't matter. We're just going to let that go. And so I simply add that for what it's worth. So, Your Honors, if I might move now to the issues with the jury verdict form. And it's one of the rare occasions where if we were in person, I would pick it up, give it to you again, because the spacing, the visual of it, the way the jury experienced it actually does matter. Your honors know it's at 432 and 433. I think, Ms. Hudson did a fabulous job of pushing back what I was saying, and I tried to push back in my reply. If we look at it, I think, I would hope anyway, that your honors, when writing your opinion and ruling in this case, would not say this is a verdict form that we ought to keep using. This is a good verdict form. I don't think it's a good verdict form. I laid it out in my brief. The initial question of and or just really shouldn't be there. And so when you write your opinion, I hope you will join with the other courts who say, trial judges, let's get the and or out of jury instructions, jury verdict forms entirely, because it does enable them to look at that and say, all right, do we unanimously find that he was guilty of object 1 and or object 2? Yes, that can happen if 9 people agree on one, 9 people agree on the other, but no 12 agree on any one of them. Now, I know the response, and it's a good response.
Well, is your argument that the instruction, we the jury unanimously find, doesn't apply to the specific verdict on the 2 particular charged offenses? What's at the bottom of page 432?
Your Honor, may I answer your question? I'm way beyond time, and I apologize. May I go ahead?
Yes, you may answer. Yes.
Okay. Your Honor, the answer is yes, sir. We stand by what we say in our reply brief, that when you look at the second question, we don't have we the jury unanimously find there. And in fact, it goes from first person to second person. So if you did try to read it together, it's already quite awkward. We the jury unanimously find, if you find the defendant guilty, state and so that itself pulls them apart. And again, it was quite ambiguous. Thank you for the extra time. I appreciate it.
Thank you. All right, Ms. Hudson.
Hi, good morning.
Ms. Hudson, let me get right to it. We come on, I know it's conspiracy in the Fourth Circuit and the laws, and you don't have to know everybody in the conspiracy. You don't have to know every detail of the conspiracy. We know that. But aren't we going a bit far now where no one in the conspiracy even testified? And we are grappling with the records to try to piece together maybe a sentence or words to say there's any knowledge. I mean, it's understood that he sold drugs to Sino. I think counsel had to agree to that. But a conspiracy, Sino didn't even testify. So can you tell me how beyond a reasonable doubt is a conspiracy proven here? That's what I want you to start there.
Yes, Your Honor, I'll be happy to do that. First of all, we did, before I get to Mr. Sino, Bradley Chapman did testify as the government's first or one of the first witnesses, and he certainly established through his testimony the participants and pattern of the organization as it existed in Southwest Virginia, explaining to the jury about Richard Cayenne and Tracy Callahan and Mr. Sino, their sub-distributors, the fact that they were getting the drugs in from Las Vegas, and the money going from Southwest Virginia back to Sino, Cayenne, and other people in Las Vegas. So we did have that testimony at the trial.
You proved that a conspiracy existed. The question is, did you prove that he was a part of that conspiracy?
And we did. And of course, the court knows, and we've had some discussion now already about the telephone calls that were central to the government's case that preceded the discovery of the 2 pounds of methamphetamine in Mr. Sino's car, which came directly from Mr. Siegler's house. I'd like to focus on the second of those telephone calls in order to answer the court's question, Your Honor. And in that second phone call, we've had some discussion today about one portion of the call, which is important and establishes very clearly when Sino is talking to Siegler that Sino is negotiating on behalf of a third party, that Mr. Sino is a middleman, and therefore that there are other people involved in that conspiracy. His words were to Mr. Siegler, from what I understand, it looks like it's going to be a deuce. He's clearly talking about what he understands from someone else. And that's not all. He goes on, Siegler says, okay.
What's going to be a deuce?
Whatever deal that they are talking about, the deal that is
I mean, in other words, from what I understand, looks like it is 2 keys. For what I understand, I'm going to buy 2 keys of meth from you. That's a conspiracy. That simply could mean easily that, okay, from what I understand, based on who I'm going to be selling drugs to, I'm going to need a 2 from you. Well, how's that? How is that Mr. Siegler knows that he's a part of the conspiracy? Just saying, I got to find out how many customers I have. So Mason, right now, I think I need a deuce. So what? How does that prove that he's in a conspiracy?
Well, there's more.
Okay, give me some more then, because that doesn't do it. Go ahead.
That phone call goes on. Siegler says, okay. And Mr. Sino says, and I would just put a caveat here. This is, I'm sure, not absolutely exact, but it's as close as I could get from listening to the tape. Sino says that
in a case like this, you spend all this money. Why didn't you get it transcribed?
I'm sorry, I don't know. I don't know if it was because the tapes were very clear or the phone calls were short. I don't know, but for whatever reason, they were not transcribed. But anyway, Mr. Sino says, but I will know for sure. In other words, following from what I understand, it looks like it's gonna be a deuce. Mm-hmm. Then Siegler says, okay. Then Sino says, but I will know for sure as soon as I get to the girl's house in the morning, when he or it, I couldn't hear exactly what that word was, gets there. Then Sino continues and said, that'd be cool, right? So a few hours, if I know by 9:30, like by 9:30, maybe we can have lunch at 12, maybe. Siegler says, and this is critical, yeah, well, we can do that. I'm going to call him right now and make sure everything's something. I can't hear the word that follows everything's. And I'll set it up for today. Those are Siegler's words. I'm going to call him right now and make sure everything's something, and I'll set it up for today. Then Sino responds and says, I always like to make sure that I've got what I've got coming, have it in hand for sure. I don't ever want to put you out or make you do something for nothing. Siegler says, yeah, definitely. And then Sino reiterates again, but I'll know for sure by 9:30, 10 at the latest tomorrow. And then, okay, I'll talk to you then. So
is that it?
Well, that is it for that second phone call on March the 8th. And then, of course, we know in the morning there is another conversation between Sino and Tracy Callahan, where they confirm that it is going to be 2 pounds. Sino wants $20,020, and they talk about whether it's going to be the same place. And Callahan said, "Yeah, where you always do this deal." And then then the next phone call, the last of the 4 phone calls, the one on March the 9th between Siegler and Sino, is a very short and sweet, I would say, phone call where Sino says somewhere into the conversation, what time is going to be good for you? Siegler says, I'm ready whenever you are. Sino says, okay, you're all set then. Siegler says, yeah. Sino says, all right, give me 45 minutes. And they have a discussion about lunch and the lodge. And as we know, then the physical surveillance corroborates that, in fact, Sino is seen at the lodge picking up what appears to be food and going into Siegler's house. So from the government's perspective, those phone calls leave no doubt that Siegler understood that Sino was negotiating on behalf of a third party, that Sino was talking to other people, that Sino wanted 2 pounds of methamphetamine for him, that he wanted approximately $20,000 in payment for those 2 pounds of methamphetamine. And what is clear from Siegler's response in the second March 8th call is that Siegler says on that call, he's going to call his guy and get the deal set up for today for his part of it. So I think that's critical to this conversation as well. So the government's view is that is absolutely.
So you're proving 2 separate conspiracies? Another one now? You said whoever that was he was going to talk to, that's a conspiracy too?
I'm just saying that the fact that another person is clearly involved in the chain now, with Siegler's mention that he is going to call him right now and he's going to set it up for today, it's clear that the conspiracy involves the Southwest Virginia people, in particular here, Tracy Callahan, Mr. Sino in Las Vegas, Siegler in Las Vegas.
Yeah, but Ms. Hudson, you jump into all of this stuff you talked about after Sino talking to what's going on in Virginia. There's no proof that Mr. Siegler knows anything about that. Whatever it meant, like, okay, right now is a deuce. Well, that simply means that, I mean, Sino cleared up the quandary as to how much I'm going to buy from you and people in Virginia. But what would they have to do with it? This seems like just a classic drug sale. If you would say this, that you can prove this simply because, okay, you sell drugs, then that means you must have gotten them from someplace else, because unless you got your own coca leaves, I guess you does. Every drug purchase would be a conspiracy. They say, well, that must have come from there, and somebody in South America must have ventured it. No, and then the other part is just as bad, because the buyer says, right now I want 2 keys from you, but I gotta clear up how much I want from you. And they go up with other people and clear up how much they need. That means you're involved in a conspiracy in Virginia with Sino and his people. I mean, it seems to be nothing more but a drug purchase.
I think the government had to prove that the conspiracy existed in the Western District of Virginia. I think the government had to prove that Mr. Siegler had a meeting of the minds with at least one other conspirator in this case, with a purpose to, as set forth in the indictment, to distribute methamphetamine. And I think the telephone calls that we've introduced, corroborated by the physical surveillance and the physical seizure of the actual 2 pounds of methamphetamine, establishes that clearly. It might not be the most voluminous evidence, but the government would argue that the evidence we have spoke loudly and strongly and was absolutely sufficient to sustain the jury's verdict in this case under this court's precedents, which clearly state that a buyer-seller transaction in conjunction with a substantial quantity of drugs is sufficient to support the inference that there was a conspiratorial relationship between the 2 people. And here, where there is a $20,000 methamphetamine deal for 2 pounds of methamphetamine, we think we've met both of those marks, Your Honor. So on that, we believe we should prevail on the sufficiency argument. Regarding the verdict form, on the unanimity question, the government's position is clear, I think, from the briefs, but I'll just reiterate here that first, the plain language of the form obviously states, we, the jury, unanimously find as follows, with a colon, and our argument is that the face of the form reflects that everything that follows, in fact, was unanimous. But perhaps even more importantly, the court's instructions on in multiple places in the instructions told the jury that their findings must be unanimous. The court then particularly told the jury that regarding the first question, their finding had to be unanimous, and regarding the objects of the conspiracy, their findings had to be unanimous. The court said in particular, although you must unanimously agree that the conspiracy had at least one of these alleged objects, you must unanimously agree as to which objects the government proved beyond a reasonable doubt. So again, under this court's
Ms. Hudson, where were you reading in the record for what you just read?
I was reading the court's instructions at JA 406 regarding the particular, I would say the 2 questions on the form, and in particular the objects, the unanimity instruction on the objects of the conspiracy, but also at JA 396, the court told the jury that they must make unanimous findings in this case generally. So in our view, there can be no doubt when the verdict form regarding unanimity is viewed in the context of the court's instructions collectively, there is no doubt that each of these jury's findings was unanimous. The instruction regarding the 843B object, as Mr. Davidson pointed out, we agreed in the brief that it appears the court had made an error because clearly the statute does require a felony drug offense. But as we argued in our brief, it is just stretches beyond any reason, in our view, to consider that this jury might have made a finding based on marijuana, where the evidence in this case was absolutely about methamphetamine, and clearly regarding Mr. Siegler, even more particularly about the events of March 8th and 9th, as evidenced by the telephone calls, physical surveillance, and the vehicle stop on March the 9th. It is just, I would argue, almost impossible to think that the jury would have made some finding based on marijuana in this case. The court instructed the jury that methamphetamine and oxycodone, in particular, the two substances alleged in the indictment, were controlled substances. Again, the evidence in this case was not about marijuana. It was not. It was just not the case. It was a methamphetamine case, and where
So
the jury also.
So
Sorry.
the jury knew that a controlled substance is a felony?
The court did not instruct the jury that any particular offense was a felony. He instructed them that methamphetamine was a controlled substance and that oxycodone was a controlled substance. But I don't believe the court specifically told the jury that any particular controlled substances of offense was a felony. Of course, I would point out that I don't think the jury would ever be asked to find whether a particular offense was a felony. I think if the court had said anything about the felony offense, it would be more likely that the court would have, just as he did instruct them that these particular substances were controlled substances, that it would have been more likely he would have instructed them as a matter of law that, for example, distribution of methamphetamine is a felony and so forth. But I don't think that particular instruction was there. Our argument is that on the evidence of this case, and particularly in light of the jury's specific finding, not only that Mr. Siegler committed both objects to the conspiracy, but that methamphetamine was the substance and that it was more than 500 grams of methamphetamine, that there was no question here that the jury was confused about whether or not marijuana was the subject of this case. Trying to think if I have.
I want to make sure, since you're hesitating there, it's dangerous to hesitate in front of appellate judges. We'll ask you a question. But are you basically saying that buyer seller, just by the amount alone, would be enough? That because it's a high amount of drugs and money, that could be enough to prove beyond a reasonable doubt that it's conspiracy? Is that what you're saying the law is in the Fourth Circuit?
Yes, Your Honor. And more particularly, I'm saying that evidence, as this court said in Mills and Reed and Yearwood, evidence of a buy-sell transaction coupled with a substantial quantity of drugs would support a reasonable inference that the parties were co-conspirators. And by way of example,
a reasonable inference. What's the standard here? Beyond a reasonable doubt, isn't it?
Yes, Your Honor.
Okay, go ahead.
And I wanted to simply point out by way of an example, in response to the court's question about the quantity of drugs, that in the Yearwood case, the amount of drugs involved in that case was 5 ounces of cocaine base for $3,500. So our view is that in light of those precedents, a $20,000 2-pound methamphetamine deal would certainly be viewed as substantial and sufficient to support that inference.
In those cases you cite, did someone testify in those cases? Because this is a case that's kind of unique. Nobody testified in this case at all, even about the drug offense.
Well, I would argue, I'm sorry.
You're right. Somebody did talk voluminously on what was going on in Virginia. You're right. But in terms of conspiracy that occurred, alleged as to Siegler, nobody, even Mr. Sino, didn't say anything. He didn't testify. I suppose you got his evidence in because you got it in through proving a separate conspiracy, how you got the hearsay in.
Well, what I would say is that regarding Mr. Siegler, I was going to say is that although Mr. Sino didn't testify, and it would have been certainly interesting from the government's view to have had his testimony in the record, but in response to the court's question, I think I would say that we had the recorded voices in the telephone calls of Mr. Sino and Mr. Siegler through those telephone calls. So the government's evidence had their actual words.
They are at best cryptic. Whatever happened to the rule of lenity in law? I mean, it doesn't exist anymore. It doesn't. Okay, all right. Well, he said dues, that means he had to have been two. And he says, because he said dues, that means he must have been conspiring with somebody else to tell him how much it was. All of this comes from, it's amazing.
Well, it's hard. I would argue, Your Honor, though, that look, taking that one statement of Mr. Sino's, he understood it to be a deuce, out of context is one thing. But when you put it in the context where Mr. Siegler delivered 2 pounds of methamphetamine to Mr. Sino the very following day, consistently with their telephone conversations, I think we've certainly gotten over the line in this case. But that's the government's view.
It's listed when he sold him drugs. Exactly. I agree with that. I'm not sticking my head in the sand on that. Yeah, once I decide how much I want, yeah, I'm buying drugs from you. That was understood.
And the quantity of drugs here we're arguing is so significant that it was clear to Mr. Siegler based on this that there was a conspiratorial activity here where Sino is negotiating as a middleman on behalf of third parties in addition to the substantial quantity of drugs. So
I understand. Go ahead.
If there are any further questions, I'll be happy to answer those. Otherwise, we'd rely on our briefs. Thank you.
Thank you, Ms. Hudson. Mr. Davidson, you have some time reserved.
Thank you, Your Honor. Sorry, I was on mute briefly. Your Honor, if I may pick up where Ms. Hudson just left off. I want to do right by Judge Agee's question because I never, ever want to misstate a record to an appellate court for any reason whatsoever. I would simply say, as best I could today, I don't have a transcript, and that has been a little difficult. But having listened to those recordings a few times, I would describe them, and I'm an advocate, and I know that, but I would describe them as ambiguous. I think cryptic is a good word. Certainly, I can live with the evidence of conspiracy maybe being slight or light, but we just don't have substantial evidence beyond a reasonable doubt here. I think the question before the court is whether you're going to set a new boundary. Hackley said that's our lowest boundary. We won't go below Hackley, and I think this would go below Hackley. If you say that a buyer-seller agreement, especially one, not a series of big ones, but one on March 9th, is enough to be substantial evidence, not slight evidence, not some evidence, but substantial evidence beyond a reasonable doubt of conspiracy, you'll be driving a circuit split. I don't think it's been the law in this circuit that a buyer-seller agreement alone on one day of a substantial amount gets you a conspiracy and we're done. If so, then we really don't have a difference between conspiracy and the underlying drug sale anymore. They've essentially merged, and then we just get into interesting discussions about why people make the indictment choices they do. What we have in this case, without Mr. Sino having testified, he was on the government's witness list, but they didn't call him to testify. I wasn't trial counsel. I don't know defense's perspective on that. They may have been caught unawares. I don't know. But what we do have in this trial, not from sentencing later, but in this trial that the jury heard is one day, one deal, and we simply say that's just plain old not enough. I would answer any other questions, and if there are others, I want to take the opportunity to thank you, Judge Gallagher, Judge Agee, and Chief Judge Gregory for taking the time to listen.
All right, thank you. So, Ms. Hudson, are you still with us? I just want to let you say that, first of all, Mr. Davidson, we note that you're a court opponent. I want to give a special thanks to you. The court appreciates lawyers like yourself who help us on these cases and take these cases. Very much appreciated. And Ms. Hudson, obviously, thank you for ably representing the United States. We can't come down and shake your hands in this virtual existence, but please know that our spirit and gratitude nonetheless. And,
thank you so much.
Be safe and stay well. And thank you so much.
Yes, sir.
Thank you.
All right, we'll have just a very, very brief adjournment of the court, and we'll proceed. Thank you.
Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, morning, Mr. Bosson.
Morning, Your Honor.
Morning, you may proceed.
Okay, thank you, Your Honor. May it please the court, my name is Tim Bosson. I represent the appellant Hester Prynne. Ms. Prynne seeks by this court action to be removed from the Virginia Sex Offender Registry because her inclusion for life violates both the ex post facto and due process clauses of the U.S. Constitution. Addressing the ex post facto count first, I want to focus on the uniquely troubling provisions of the Virginia Registry. These are restrictions or issues not presented in the seminal case of the Supreme Court, Smith v. Doe, nor by any court faced by this, or nor by any case in front of this court previously. The first such provision is the assignment of a supervisory officer to Ms. Prynne. This is found in the Virginia Code 9.1907C, which states the Virginia State Police should physically verify a registrant's information at least semi-annually during their whole term on the registry. Virginia effectuates the statute, as we pled in our complaint, by specifically assigning an officer to Ms. Prynne to whom she must report all her required registration matters, who is also permitted to and does randomly check on Ms. Prynne at any time at home or at work. And additionally, every 2 years, and this is found in Code Section 9.1903I, every 2 years, Ms. Prynne is required to sign a consent form for this officer to access her electronic communications to determine the veracity of her electronic identity information. When considering the question of parole or probation, the Smith Court found compelling that there, the petitioners were free to move and to live and to work as other citizens with no supervision. Similarly, the 10th Circuit found in the Shaw v. Patton case addressing the Oklahoma registry that, and in that case, finding that in-person reporting was not akin to probation, the court stated, there was no specific officer assigned to consult with the registrant or to supervise him. The absence of supervision distinguishes the reporting requirements from the historical understanding of probation. A supervising officer is not required by the federal SORNA law, and so this court did not take this issue up in the U.S. v. Under Seal case or the recent WAS case. Now, if you apply Smith's finding then, that as to supervision and the assigning of a supervising officer, it makes Virginia's registry, makes very clear that Virginia's registry is akin to probation or parole, and that this level of supervision creates an affirmative disability and restraint on Ms. Prin's conduct, which makes these two factors weigh heavily in favor of Ms. Prin. The second issue presented here, not presented in other cases, is the branding of Ms. Prin with a level of dangerousness. In 2001, 7 years after Ms. Prin had pleaded guilty, the state retroactively decided, sua sponte, that Ms. Prin was a sexually violent offender. They then notated on her registry page, open to the public, with the statement of violent, yes, a statement that would appear in the present tense that Ms. Prin is violent. That was changed by statute. I want to notify the court to this fact since this case has been pending in July of this year. And so instead of stating violent now, it does state tier 3, yes. That's really just a matter of semantics and doesn't change the fact because tier 3 is the highest level of dangerousness. And the Virginia State Crime Commission website actually says that tier 3 is the most serious level of sex offender. And I can assure you that Ms. Prin, a 54-year-old grandmother, a model citizen, is not the most serious level of sex offender. As the Sixth Circuit found in the Snyder case where they struck down the Michigan registry, a registry that was very similar to the Virginia registry we're looking at here, the court found there that the tier classifications, quote, ascribe and publish the state's estimation of present dangerousness, and therefore it equates to shaming and branding of the offender. And unlike the Smith case, where the Supreme Court...
Counselor, as I understand those punishments from colonial times, those were very public. As you walked about in public, you could see by actual branding that those had happened to an individual. Here it appears to be different because if someone wants to find out those things, they have to go and look for them. It's not evident if you simply see someone out in public. Why isn't that a material difference?
Yes, Your Honor. I would note, when you're looking at the factors, the question is it like these other things? So it doesn't have to be exactly the same as shaming or branding historically, but I understand the court's position. And I would say there's two differences here.
Well, it's not a position. I just ask a question.
I'm sorry, Your Honor. I apologize. But there are two issues that are presented here that were not presented in the Smith case and in more historical cases. The first issue is that Virginia has an active registry. It actually, by law, requires schools, nursing homes, and assisted living facilities in Virginia to sign up to receive notifications of any identification changes by anybody locally on the registry. Meaning, if Ms. Prin so much as changes her car registration, every school in her area gets notice actively. You know, it comes to their computer of her change. And I would also note that the internet is so ubiquitous now. Virtually everyone's on the internet, and you know, and other courts have looked at this as well. It's not just the registry itself; it's that other third-party sites pick up the registry and broadcast it out. You know, you location-wise or whatever, and it sends it out to people. So. Your Honor, I believe that's how, you know, it has become far more of a public issue than it was, you know, even 20 years ago, especially in Virginia, the way the system is set up. But. Now, I was noting that unlike Smith, in the Smith case, the court found there that the Alaska registry only disseminated accurate information about a criminal record that is public anyway. But here, Virginia is actually publishing false information. It's decided wrongly that Ms. Prin is violent. She's never been violent. She did not plead to a crime that was a violent crime, and she's not violent today. And regardless, the information does not just restate her crime that was committed back in 1993, allegedly, but it creates a new hurtful and false label that would otherwise not be in the public domain but for the registry that was set up by Virginia. And I would note, assigning and then publishing a current level of dangerousness is a new issue for this court. It was not raised in under seal or WAS or any other court or any other case from this court.
Let me just ask a question. The tier 3 designation, the change from violent to tier 3, isn't tier 3 premised on the nature of the underlying conviction? So it's a little bit different than the argument you were making about using the label violent, which could be construed to be a present assessment of danger.
It is slightly different. I would note that the Snyder case, the Michigan case, was addressing this issue exactly. There in Michigan, they said tier 3. They did not say sexually violent as Virginia used to. So that is an issue. But still, if you go to Mrs. Prin's page today on the registry, it says tier 3, yes. Tier 3 is defined. If you Google tier 3, of course, now all that shows up is sexually violent offender. And even the Virginia State Police's pamphlet that, or guidelines, excuse me, that we attached as Exhibit A to our complaint has been amended to say tier 3, formerly sexually violent offenders. So there's really no daylight between tier 3 and sexually violent offenders on the internet, which is where it really matters. But I would just say specifically to the court's question, it says tier 3, yes. And then tier 3 is defined, if you look it up, as the most serious level of dangerousness. So again, and just like the Snyder court found in the Sixth Circuit, you're basically labeling, you've decided to label Ms. Prin retroactively from her crime date as the most serious level of offender in Virginia, and it appears on the website to be active. It doesn't say she was formerly convicted of a tier 3 crime. You know, that would be clarifying. That would be public information already, but instead it's tier 3, yes, to imply that she's currently at that level of dangerousness. Now, the third issue, and I think this is a very important issue to address, is this issue of rational connection between the Virginia registry and the stated non-punitive purpose. Here, because we were only on the pleadings, the court looked at the stated purpose of the statute, and then our evidence in the record, which was 3 empirical studies attached to our complaint, exhibits B through D in the record, and said there's a rational connection, even though our empirical studies showed that what's actually happening with these registry statutes like Virginia is the opposite effect, that it's increasing recidivism, if anything. On the record itself here, if we go no further, this would be an incredibly damaging result, because the trial court basically said it doesn't matter what the evidence is, doesn't matter how irrational or unreasonable the statute is, if it's actually producing the absolute opposite effect, it still passes this rational connection test, and that's just not proper. Now, finally, the final issue is the excessiveness of the registry as it relates to Ms. Prin. As the record reflects, Ms. Prin is a model citizen. She's not violent, never has been. She's virtually not a threat to reoffend, and yet she's subject to virtually all the restrictions found on the Virginia registry. And her failure to comply with even one of those is a felony under the law. And so unlike in Smith, where the court noted that the Alaska registry, we'll strike that, I've already gone into the fact that in Smith, the Alaska registry was passive and was not passed out to anyone who asked for notification. And in here, Ms. Prin is also on the registry for life. And as we talked about in our brief, the only way she gets off the registry is if she's dead or incapacitated. So the registry as it relates to Ms. Prin is clearly excessive on the record. We also have a second count as substantive due process. I'll rely on my briefs primarily for that. I just would notice that the fundamental rights of travel and interstate travel and the fundamental right to parent have been, there's a long history of the courts finding those to be fundamental rights, and they should be protected. And this statute is not narrowly tailored to serve the compelling state purpose in this case. Unless the court has any questions for me, I will reserve my time.
All right. Thank you, Mr. Lawson. Ms. Callan.
Good morning, Your Honors, and may it please the court. Michelle Callan for Appellee Colonel Settle. At the heart of this case, at its heart, this case is an ex post facto challenge to Virginia's sex offender registry. But the U.S. Supreme Court has rejected such sex offender registry. And this court has repeatedly rejected such ex post facto claims, including to Virginia's sex offender registry. And because Virginia's registry is similar to those of other states, a decision in appellant's favor might not just invalidate Virginia's registry, but may well be invalidating North Carolina's, South Carolina's, West Virginia's, and Maryland's registries as well. Now, on that ex post facto piece, this court has held on multiple occasions that sex offender registries like Virginia's do not violate the ex post facto clause. Not only did this court hold in Ballard with regard to Virginia's sex offenders specifically, but as recently as this past spring, this court reiterated its holding in Under Seal that the Federal Sex Offender Registration and Notification Act, SORNA, is non-punitive and thus does not violate the ex post facto clause. And that's the Wass case discussed in our 28J letter. Appellant has not and cannot show that the federal SORNA is so materially different than Virginia's sex offender registry so as to justify finding Virginia's unconstitutional while affirming this court's multiple holdings that SORNA is constitutional. Now, I'd like to address the two-step analysis in Smith. Under step one, that step is not disputed here. Appellant waived that point in her brief. And that makes sense because the act itself, in the act itself, Virginia's legislature was clear that the act's purpose is civil in nature, to protect the public. And the act is located in the civil part of Virginia's code, just like this court analyzed with regard to SORNA in Under Seal. The purpose of Virginia's sex offender registry, just like SORNA, is to ensure that people are aware of sex offenders when they decide where to let their kids play, where to shop, and where to let their kids trick or treat. So that brings us to step two of the Smith analysis. Appellant has not shown, much less by the clearest proof.
Counsel, may I ask you a question? If a person lived in the far reaches of Virginia or any other Virginia, for example, and there was no one within really 100 miles of them, wouldn't it still apply to them?
Yes, Your Honor. The registry applies to people based off the conviction. It applies based off the conviction, not based off the person.
So it's not, but I was addressing the point you said is to make sure people know, you know, when they go to the grocery store, go to schools, they stay away from people who are on the register. But even if they're away from people on the register, isn't that sort of is aptly styled in this case, a Hawthorne type scarlet letter? Is the purpose?
No, Your Honor. I mean, I take your question to apply to the first step of the Smith analysis, the purpose step, and Virginia's legislature was very clear, and that's in Code Section 9.1900 as to the purpose of the sex offender registry. And that's consistent with this court's analysis and Under Seal, both looking at the stated purpose, but then also at where it appears in the code. There is an area in Virginia's code that's criminal, and that's not where this provision is. It is within the civil part of Virginia's code. And so the step one is the conclusion under step one is that Virginia's legislature did not intend for this to be penal. So then that takes us to step two, where the plaintiff must show by the clearest proof that even though Virginia's legislature intended for the law to be civil, its effects are nonetheless so punitive that it overcomes the legislature's intent to create what is a civil scheme into a criminal scheme.
Isn't that what the plaintiffs here are saying, that you have a person in their mid-50s, you see, counsel said a grandmother, this happened a long time ago. You're closing the door on any idea of redemption of a person living their lives totally different or whatever that may be. Isn't that a sense that it works to that? Particularly since you upped this, it wasn't, this offense wasn't classified at this level at first. In Virginia, so this is a unique situation, isn't it? You got some other tiers in there, isn't it? A little different. You up there, call it a violent felony, and then recently changed it, but the third tier is very easy to, as counsel said, to look on the other side of the ledger and say, oh, this is the highest level of sexual violence.
So there it's important that the scheme looks at the crime of which the person was convicted and not the person herself. And the crime of which the appellant here was convicted was taking indecent liberties with a minor under her charge. In this case, a minor, a boy who was 15 years old. And I think it's important to note that Virginia's classification of this crime as a tier 3 crime is by no means an outlier. Just to name a couple of examples, New Hampshire, Nevada, Kansas, Florida, Oklahoma, all designate this offense as a tier 3 offense. And so I think it's important to note that the analysis that the Supreme Court grappled with in Smith and that this court has adopted is not specific to the individual. The ex post facto analysis does not entitle an individual to an individualized assessment. And I'll also note that there's no procedural due process claim here. So when we're looking at the ex post facto analysis, it's about the crime and the retroactivity of the crime and the elements in Smith.
Well, since it's about the crime, under Virginia law, taking indecent liberties with a minor, does that require any violent act?
I think it depends what Your Honor means by violent. I
mean by the elements of the statute and how it can be prosecuted. Does it require any violence? It's just the elements.
No, Your Honor.
It doesn't require any violence, does it?
No, Your Honor. And Virginia now labels that a tier 3 classification, just as numerous other states do. And so the focus there is the fact that the minor was under the person's charge. So here it was a nanny in her mid-20s having intercourse with a 15-year-old child under her charge. And so and she pled guilty to that. And so the focus there is the age of the victim, which here is 15 years old. And then also the fact that the minor was under her charge. And so Virginia is by no means an outlier categorizing this crime as the highest level of offense.
But you told me it was about the offense, and then your retort immediately was what happened in this case. But then when we look at classifying crimes, we look at based on the elements, sort of a categorical, if you will, look at it. So the category would include, it's basically like, it talks about lascivious acts in the presence of concerning a child, right? You could flash someone and that be guilty. Couldn't you in Virginia? Couldn't you flash in front of a minor and be guilty to that offense?
No, because that offense involves a minor under the person's charge. And so I think it's important.
A person you're babysitting, you flash in front of them while they're watching the cartoon. Wouldn't that be a part of the thing?
I'm not sure, Your Honor.
Well, you should know in terms of what you told me. We should focus on the offense, and you tell me you don't know the offense in terms of Virginia, that you classified this person as violent. I would tell you that's even more so. How random and arbitrary, isn't it?
No, Your Honor.
You don't know the elements of the offense in which you call violent?
So I think it bears noting, Your Honor, that the offense, as my friend on the other side recognized, the offense is not labeled violent, non-violent. It's a classification based off tiers along the lines of precisely what the federal SORNA does.
Right. Is there a tier higher than, in terms of level of dangerousness or violence, higher than 3?
No, Your Honor.
Right. Okay, go ahead.
But I think it makes sense then to take a step back and recognize where we are then with regard to the ex post facto analysis. So even if this court concludes that the classification of tier 3 is broader than it needs to be, the question under Smith step 2 is whether the plaintiff has shown by the clearest proof that even though Virginia's legislature intended for the registry to be civil, its effects are so severe that they overcome the legislature's civil intent. Many of the arguments that appellant raises as to the specific Mendoza-Martinez considerations have already been rejected on multiple occasions, and we lay them out in our brief. I'd like to...
Sorry, let me interrupt with a question. You're talking about the plaintiff's burden to show with the clearest proof. This case was decided on a motion for summary judgment, so there was no discovery as to the statute on Ms. Prynne or anyone else. Doesn't that distinguish this case from some of the other cases that were cited, which were decided at later stages of the proceedings?
Your Honor, this case was a motion to dismiss. And there are a number of cases also that address the issue at a motion to dismiss. In fact, this court's decision in Doe v. VSP was at a motion to dismiss. I'd also direct the court's attention to an Eighth Circuit case. It's called the Weems case v. Little Rock Police Department. That's 4453 F. 3rd 1010 from 2006. That's an Eighth Circuit case that decided an ex post facto, that affirmed a motion to dismissal of an ex post facto claim at the motion to dismiss stage. And I think it makes sense also that a number of the cases that were raised in this case, for example, the Smith case, were not resolved in a motion to dismiss because a number of those cases predate the Twombly-Iqbal test. And so the question is really whether or not there's any discovery that would make a difference here, and whether surviving a motion to dismiss makes sense in light of that. And my friend on the other side has not pointed to any discovery that's necessary. This case raises legal issues, and we accept all the allegations in the plaintiff's complaint as true, but notwithstanding them, they don't state a claim as a matter of law under the Smith ex post facto test. I would like to address the points that my friend on the other side raises with regard to probation and parole. Again, here, Virginia's sex offender registry is not an outlier. Life without parole and registration are qualitatively different. And as the Supreme Court explained in Smith, unlike parolees, sex offenders are free to move wherever they wish, and they need not seek permission to change their appearance, to borrow a car, or to seek psychiatric treatment. Numerous other states have supervised release type structures like Virginia's. Maryland, North Carolina, South Carolina, Louisiana, all of them have a similar monitoring of sex offenders in their registries, and invalidating Virginia's on the basis of some sort of similarity to probation or parole would call into question all of these aspects of those sex offender registries. I think it's also important to note that even if this court views some resemblance to a criminal scheme, some resemblance is not enough to transform a civil statute into a criminal one in violation of the ex post facto clause. Even if there is some similarity, Smith still instructs us that this factor need not weigh in favor of rejecting the legislature's intent to create a civil scheme. So taking a step back, even if accepting appellant's arguments here with regard to probation and parole, that's not enough to create the clearest proof that the registry is punitive in effect. And I think it bears noting with regard to the ex post facto piece, that really the burden is very high on the plaintiff to overcome the significant deference that this court accords the legislature's stated purpose of creating a civil statute.
Ms. Callan, ask your question. When we assess whether it is punitive, through whose lens do we look at it? Do we look at the impact on the person's life? Wouldn't that have to be the metric? I mean, because the state, all right, we label it over here, label it there. It's civil, so it's not punitive. That can't be the end of the inquiry. You agree with that, right? What they label it as, right? You agree with that?
Certainly, Your Honor.
Okay, all right, that's a, now, if labeling it alone is not enough, then don't you have to look at something that kind of goes back a little bit with Judge Gallagher's question, at least in my mind, it triggered my mind. I don't know what Judge Gallagher's intent was, but it triggered me in mind. The question is, don't we have to look at maybe perhaps some evidence as to how this is punitive in terms of their lives, in terms of it's preventing them from being around children, their grandchildren, or carrying on their occupation? All of these things that you say, these things are terrible. I mean, you go on that thing and you can get little red pens in your neighborhood. It will tell you exactly where every person lives that's on the registry. And you can go ride by their homes, and they're subject to derisive looks. And, oh yeah, that's the one I saw. I don't even know the person. Never having a chance to even assess the quantity of their character. But just to say for the rest of their lives, yeah, that's her. That's where they live. And don't we have to look at those things in terms of for the rest of, and Virginia at first did not make this an offense that was for life, right? At one point, and you could apply and it would not be. Later on, they changed it, right? To make it forever, no matter what you do, you could find a cure for cancer. You could, whatever you might do, find a vaccine that we're all hoping and praying for right now. It wouldn't make any difference. You're still on the register.
I think part of that is, yes, Your Honor, and I think it bears noting that the appellant here pled guilty before there was any registry whatsoever. So certainly that, I think that's inherent in the nature of the ex post facto analysis, and that's part of what the Supreme Court grappled with in Smith and what this court has grappled with in Under Seal and recently in Was. As to the specific kind of question about the as applied nature of whether we look at the individual, we're not aware of any court that has ever thought of the ex post facto analysis as an as applied test. And I think that makes sense because the ultimate question is whether the legislature imposed punishment under the ex post facto analysis, not an as applied inquiry as to whether this is punitive or not as to a particular individual. And that's why the registry, it focuses on the crime to which the person was convicted and not as to that particular individual. I'd like to just briefly address the due process aspect of this case, unless the court has additional questions on the ex post facto analysis. As to due process, I have 3 points, Your Honor. First, justiciability. Second, applicable level of scrutiny. And third, the particular rights that appellant asserts. Appellant lacks standing to bring a number of the due process challenges, and her challenges are not right. So for example, her challenge regarding entry into schools. The Act sets forth exceptions to restrictions regarding entry into schools, and appellant does not allege that she ever attempted to avail herself of those exceptions to enter school campuses. And I think some of that gets to your point, Chief Judge Gregory, about how the registry works on the ground. I think a lot of that then goes to the due process analysis, and then the question becomes, they are under due process. It is relevant as to justiciability as to whether they apply to the particular plaintiff at issue in the case. So that's the first point on justiciability with regard to due process. The second point is the level of scrutiny. Now, appellant insists that simply because she invokes fundamental rights, Virginia's sex offender registry must be subject to strict scrutiny. But it cannot be that at the moment a litigant invokes a fundamental right, strict scrutiny immediately applies. And the right to work is a great example of that. The right to work is subject to reasonable government regulation. There are numerous federal, state, and local regulations that broadly impact people's rights to work, but we do not apply strict scrutiny to those regulations. For example, licensing for certain jobs, taking the bar, all of those are examples where we do not strictly scrutinize regulations with regard to the right to work. As to the particular rights at issue that my friend on the other side raises, as to right to parent, nothing prevents the appellant from being a parent or for being involved in her stepdaughter's life. As to the right to travel, it makes sense why we should have notification requirements for sex offenders to travel. It's so they cannot commit sex offenses out of state without being known that they're out of state. And as to privacy, courts have been clear that publication of truthful information is not a constitutional violation. Information that becomes public in Virginia is substantially similar to that in SORNA, and it's substantially similar.
Excuse me, counsel, you said make sure they don't commit a crime when they leave the state. That's the purpose of that?
I think that the purpose of the registry is to protect the public, and so it makes sense why there would be travel notifications so that
the person left the state to go to the Cleveland Clinic to be cured from a very serious malady, they would have to register, wouldn't they?
They would have to provide notification. That's correct, Your Honor, and that's
right.
and
then they're there to try to get well from the Cleveland Clinic or Mayo in Rochester, Minnesota, maybe, right? What I mean, right? No matter what the circumstance.
That's correct.
Otherwise, is the purpose really fitting that? Is that really the purpose? So that's causing question of what was the intent? Is it really punishment? It's not really to get at those things, is it? But go ahead.
No, Your Honor, it makes sense why there would be a notification because so that folks can know where offenders are. And that's why courts throughout the country, I see that my time has run out. May I finish answering the question, Your Honor?
So that folks, even in other states, will know that they're there.
That's correct, Your Honor. And so that they can't go unnoticed between various states and committing crimes in other states.
So what does Virginia do? Virginia sends out a bulletin to the state, or be on alert, the person is now in our state. Otherwise, if that's your purpose, you must try to practically affect it, right? I mean, what real time, then you could go and say, I not only know where this person lives, I know what state they're in right now. You can, do you match that with an index for the public?
So there are two pieces to the travel notification, Your Honor. One is that the offender herself both notifies, provides notification.
Right, self-notice. And what's the other part?
And then there's also a provision where officials in Virginia provide notification as well. And so there are two pieces.
Well, how does the public know that they're temporarily located in another state? Because we want to make sure they're protected now. Because you said so the people will know. How do they know that? Is it updated real time? And I can say, well, this person is out of state now.
No, Your Honor, that piece of it is not public facing. That piece of it is for officials to be able to know.
Oh, for officials to know, right.
May I briefly conclude, Your Honor?
Well, yes, you may, yes.
So certainly the registry is burdensome on offenders like appellant, but that does not make it unconstitutional. Under the ex post facto analysis and the due process analysis, we ask that this court affirm. Thank you.
All right, thank you so much. Mr. Boston, you have reserved some time. Move.
Sorry, I was trying to get it.
You're good. We can hear you.
Okay. First, I just want to address this issue of its intent versus effect. Because of the Supreme Court's decision in Smith, we did not feel like we could challenge with this court, but with the Supreme Court, we could, this issue of intent. We do agree with the court. The intent to us seems very much to be punishment. But because the facts of Smith are so similar on the intent issue as to this statute, we've not attacked that at this stage. We are attacking the effect test, though. And I would point out, I noted counsel said that, the Fourth Circuit's addressed these issues, and Ballard is an unpublished opinion. But even worse than that, in the trial court, they didn't establish the facts. They didn't talk about the registry restrictions. And so it was an unpublished affirmation. It's really completely unhelpful to this case. Similarly, the under seal case, and I know Judge Agee was involved in that case, but it only dealt with it was an early generation, not even early generation. It is the federal SORNA requirements, which are like an early generation state registry. And I'm looking at what it required. It was only the requirement to register, to appear in person, although it didn't say how often. It definitely didn't say every 3 days. If you change any information, it did not say 30 minutes. If you change an internet identifier, that was not presented in that case. And finally, the only other thing was that it was supposed to be published on the internet. So that was it. And nothing else, no supervisory officer, no shaming, nothing was presented in under seal, nothing like what we're dealing with here with the Virginia registry. And I would just say there are no cases that have come from the Fourth Circuit that I am aware of that have been cited that actually deal with the facts as we've raised them in this case. The Doe case, I do want to speak to that briefly. Doe was dismissed on a standing technicality because the plaintiff there did not go through the process of filing in the state court. She didn't petition the state court to have a right to go to schools and churches. Again, and the Doe court even said specifically that she was not challenging her placement on the registry, which is exactly what we are doing here. So there's no standing issue here, and Doe did not get to the substance, so it had no effect, or it's not helpful at all in this case either. I wanted to note, and I really wasn't going to go there, but counsel has gotten into the facts of this case, and I just want to clear the record and say this is one of the reasons we do want discovery, because the reality in this case is that my client was basically attacked by a 15-year-old, almost 16-year-old football player who was the predator in the situation and came onto her, and the only thing she didn't do was fight him off. That was her crime in this case. She is not a predator, and the facts will bear that out if we get discovery in this case. So for counsel to raise that as a factual issue that's in their favor is just not the case. Speaking of that, and I know the court has asked this question, but we absolutely want discovery in this case. Multiple of these factors require evidence. And the other courts that have looked at these cases and other circuits and other jurisdictions have required evidence. For instance, first off, simple one, to prove that the registry is rationally related, we have a right to know what the state is based that upon. In the Snyder case, for instance, the court looked at Michigan and said, have you even done a study to see if this is rationally related to your statute, to your purpose? And there they found Michigan very wanting, and I suspect that'll be the case with Virginia as well. We'd also like to know what level of monitoring goes on with the state. They take electronic communications, they take internet identifiers and make us consent to a search of our computers. We want to know what level of monitoring they're doing. I think that's going to speak greatly to the affirmative disability and restraint. And speaking of that issue, the Supreme Court said in Smith, when you look at an affirmative disability and restraint, the question is the effect on the person subject to the restraint. How can we get to those facts without discovery and the effect? And the court said in Smith, finding there, of course, they found in favor of the government, but the court said the plaintiffs there had not proven any evidence of employment or housing discrimination. It was a very factual question. We have pled those facts in our complaint. We would like to get discovery to prove those facts in this case. And the effect on my client has been huge. You talk about harm to her reputation, to friendships, to the ability to interact with children. The list goes on and on. And finally, in the Shaw case in the 10th Circuit brought this out, the question of excessiveness goes to the level of danger that the person is. So, of course, we have a right to do some discovery to prove that our client is not at risk of reoffending, and that should be presented to the court. I did want to mention one other thing. Counsel said that Virginia is not an outlier with its system of supervision. And I would just say, in looking at all the cases the many cases over the last few weeks on the registry issues, I have not found one case that's been presented to a court that has an assigned officer for sex registrants. The closest state that I'm aware of is Indiana. In Indiana, their law said the A officer can visit your house once a year. And the Indiana Supreme Court struck that statute down as being overly restrictive. So nothing like what we see in Virginia is present, but even less than that has been found to be unconstitutional. And then finally, I would just note, counsel also said that ex post facto challenges are not supposed to be as applied, but that's just simply not the law. It's not what other courts have done. The 10th Circuit case in Shaw was an as applied challenge, ex post facto. The 11th Circuit case that we cite in our brief, the Miami-Dade case, also an ex post facto as applied challenge. And I believe there are numerous other ones. Those are only the first two that come to my mind. And I think it's very appropriate for us to bring this as an as applied challenge. Unless the court has any questions for me, I believe that is all I had.
All right. Thank you, counsel. Thank you both for your arguments. We can't come down and shake your hand, but know that we appreciate so much of being here and helping us to wrestle with these difficult issues. And we thank you so much. And be safe and stay well. And with that, I'll ask the clerk to adjourn the court for today until tomorrow morning.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Thank you.